Yes, correct.
Good morning to all of you. I have a great pleasure in welcoming you all for this session on the master class on LLP, which is actually going on for the last few weeks. And our today's topic is relating to SBO, that is substantial interest of identifying who is actually the owners of the company, ultimate owners of the company, which is already there in Companies Act 2013, I think section 89 and section 19, which is actually there. Now that has been extended to the LLP. And in fact, these rules have been notified very recently, and it is actually effective. There is a certain time frame, etc., which has actually been given here. But it is better for us to understand what are the rules, what is actually called for, what is required to be done, how to identify the SBO itself, in what circumstances is there, any exemption is available. That is all about the topic today. We are actually going to discuss. Ravina is going to enlighten on this to us. And we have Mr. Thirupal, who is actually a company secretary, well experienced. He was there earlier also with us. He is not new to us. So he will actually share his thoughts. And of course, Mr. Sudhakar, our veteran, is actually there. I think I'll ask Mr. Sudhakar to formally introduce our panelists and say a few words on this before we start the topic. Over to Sudhakar, please.
Thank you, Bala, and good morning, all the participants. In fact, I don't think we require any introductions. It is because not because of the arrogance of the the panelists today, but because the kind of love and affection what we have towards Mehta and Mehta. And in fact, Thirupal is one of the busiest professionals as far as Bangalore is concerned. But however, whenever we invite him, except on one occasion only, that was last week, if I am not wrong, he couldn't accommodate us. But every time he accommodated us, and in fact, I consider myself, really we are all blessed with, because he, according to me, it seems to be, I spoke to a lot of people to bring them as panelists. Everybody says, sir, LLP is not my cup of tea. Whereas Thirupal told me, sir, LLP is my lunch, my dinner, my breakfast, everything. So that means I can consider the best of the faculty or best of the resource for LLP is Mr. Thirupal as far as India is concerned. Let me put it this way. Because I spoke to a lot of people to come as panelists. Thirupal, you may be saying knowing, but it is, I will give a certificate to you for that. Considering again this thing, that in fact, I interact with several professionals, even these days also. I travel quite often. That's the reason, one of the reasons I couldn't participate in last 2 weeks webinars. Whenever I travel, I normally interact with the people. That most of the company secretary says the same thing, that LLP is not my cup of tea, which is quite unfortunate. In fact, especially my earnest request, submission, and advice to all the young participants, especially, is LLP is equally important. And in the coming days, according to me, LLP is going to get more prominence as much as like your private limited companies. In fact, when the SBO rules have been extended to LLP, the kind of prominence what the regulator is anticipating, LLP as a vehicle for conducting the business in future, maybe that is the reason they have extended the SBO rules to LLPs also. Having said that, now as far as before I hand over to Thirupal to say a few words, let me make a request to all of you, is that today also I am in Delhi and I am joining only for about 10-15 minutes. Please permit me to excuse myself after that, because I have to go for a client meeting. And in fact, okay, let me also say one more thing, that last week I got a call from one Mr. Subramaniam from Tamil Nadu. He is one of the regular participants of our webinars in Mehta and Mehta. And he told me that he watched one of my webinar in PCAS, Bombay Chartered Accountant Society. And he called me and he told me, Mr. Sudhakar, I called you only for one thing. Can I have 5 minutes with you? I said, please, sir, tell me what I can do for you. He said, I want to do something for you. I said, please let me know. He said, I want to bless you. I said, a person calling me and saying that I want to bless you. I couldn't understand for a moment. I said, pardon? He said, I want to bless you. I said, please do that, sir. Then in Sanskrit, I know that in Sanskrit, he read a shloka and he said, after 2 minutes, he said that I blessed you in Sanskrit. This is how we do normally in Tamil. I said, I'm really obliged and I really blessed with somebody calling me and saying that I want to bless you. But, sir, what motivated you to do this? He said that at 80 years to spend some time, I watch these kind of webinars. I watched you in several forums, the kind of knowledge you are disseminating and to the participants and all. You have to have a long life, active life, and do this job in future also. So I thought I will share with you, when we do something good, this kind of what's called as, okay, the results what we get, an 80-year-old person calling me and blessing me, really, I consider it as a blessing. So sometimes I share these kind of things, not because of anything, but because only to communicate one message to you that if we do good, good will happen to all of us also.
Great, sir.
Coming to
Great,
the
great.
subject, yeah. Now coming back to the subject, in fact, significant beneficial ownership when it was legislated somewhere in the year 2018, and the rules were what's called as enforced, it was virtually next to impossible to implement that. So from ICSI, we made a representation to the ministry, and the ministry invited us, and I was one of the privileged three members, one of the three privileged members who could make a presentation to the MCA. And ultimately, 90% of our recommendations were accepted, and the rules were modified accordingly. The rules what we have in the Companies Act is, as on date, is that modified rules. More or less, the same thing has been extended to LLPs with a mere change of the beneficiary company, the reporting company has been said reporting LLP, and your all other things, just they have brought LLP. Otherwise, more or less, the rules are the same. Only thing is that, according to me, it is very complexities are more in this. One has to understand very clearly what is a significant beneficial owner. The definitions are there. What is the reporting LLP? Who is a significant beneficial owner? And similarly, who is I mean, in case the corporate is or you can say body corporate is a member, how to identify the SBO? If the HUF is going to be a partner, how to identify the LLP, I mean, the SBO? Same is the case with the trust, and same is the case with the LLPs being partners also. Like that, there are several things out there that, of course, Ravina is going to make a good presentation for all of that. And the only thing is that I want to bring one or two things when it is applicable to the companies. There is a section 89 and section 90 are there. Several times I have mentioned about this while I was delivering lecture about SBOs. Section 89, there is a registered owner and beneficial owner concept was there. But that means what? The registered owner is not a beneficial one. Beneficial owner is someone else. And so then what happens is the registered owner has to file that, I think, MGT 4, and the beneficial owner has to file MGT 5 to the company, and the company in turn has to file MGT 6 with the company ROC. In section 89, the role of the company is a mere postman. When you receive MGT 4 and 5, then you will file MGT 6. Otherwise, the company has no role to play. Company need not investigate whether the registered member is a beneficiary or not. Company don't need to do anything. Only when they file the forms, the company has to intimate the ROC. Whereas section 90, it is not so. Section 90, it is company is also under obligation, along with that individual who is the significant beneficial owner, who has to give a declaration to the company that he is the significant beneficial owner in that, that form. Whereas company, if that significant beneficial owner is not giving the declaration based on the information available with the company has to identify a person who is SBO, and they have to give a declaration to they have to give a show cause notice to the person concerned that as per our records, you are falling in the definition of SBO, and please make the declaration, whatever it is required. If it is not so, or whatever the information that SBO, that so-called SBO, if you furnish it, the company is not satisfied, you have to go to NCLT and get the restrictions imposed. So under Section 90, company also is under obligation. Similarly, in case of LLPs also, the LLP, the reporting LLP is under obligation to find out who is the SBO and do the same thing more or less. So I give a pause here with this small intro and request Thirupal to say a few words about this, and after that Ravina will take over. Thank you very much. God bless.
Good morning to all. Thank you, sir, Sudhakar sir, for giving a nice introduction about especially the blessings that you sought. We are really privileged to get the blessings online. Fortunate we are. Yeah, this last session I could miss because that the same day I was having a session here in Bangalore to address on the compounding adjudication and condemnation of delay aspect, morning to evening. So that is the reason I could not present. Otherwise, I love to share the knowledge and gain the knowledge. Okay. So as per as this subject, this is a around 4.5 years old subject, that SBO, and then now we struggled a lot in filing the forms, especially the till date. I remember the change is not properly defined. What is the change of SBO? Whether the cessation itself is SBO change. Suppose someone is holding through his company more than 10%, and today he sold the shares in the one instance in that particular company, member company. The next one, the member company also sold the shares. Two changes are there. Due to that, it ceased to be SBO. We are unable to file the forms that went to and all. I don't know whether we need to. The change is not properly defined, and they are not properly incorporated those forms. Why we are worried about it? If you look at the SBO, like you have a DIN number, each SBO will be given one unique identification number, which should be used across all companies where and all this man is a SBO. That means at any point of time, ROC or any other regulatory will be able to identify by clicking that number. Maybe not exactly, that may not be public information, but it must be available to the regulatory to identify where and all this gentleman is and was, or as a SBO of the various companies, so that they may go, like there's a concept of deemed director concept or deemed officer in default. So many other issues may trigger at later date, especially a criminal fraud investigation, all those stuff. That data may be used. Now, if I am not able to file properly to seize myself as a SBO, so I will be getting into the unwarranted trouble at the future. So this is the one submission I would like to make. So there should be some proper reporting. Even now today we have LLP, that forms are not yet notified. They're saying that we are going to take the time to notify the forms. At least this should take the this change cessation, like you have a director in a company and you file the form for appointment, then thereafter change in designation, thereafter there's a concept called cessation. Similarly, they should bring that cessation clearly with notice, whatever the person sees to be SBO. From that information, company should be in a position to file, or the SBO himself should be allowed to file that. Something is the one that is lacking in the current system. So let us hope that, let us listen to the presenter. Then if there are any questions, I'm ready to answer and learn from the panelists and other participants. Thank you.
Thank you, Thirupal. And before I invite Ravina, let me say that Ravina is one of our brilliant partners whom we have. She is heading our Calcutta branch, and Ravina is having about 12 years of experience, and she is having reasonably good knowledge as far as LLPs and SBO rules are concerned. That's why we have chosen Ravina for this. And good luck, Ravina. Thank you very much. Bless you.
Thank you so much, sir, for a wonderful introduction. Thank you, everyone. Thank you, the panelists. Thirupal, sir, you have actually given us a base of LLP SBO, which will make us to have a better understanding. So I'll, with the permission of Bala sir, I'll start with the with our webinar today.
Yeah, you can start actually. Thank you, Thirupal, and thank you, Sudhakar.
Thank you.
As Thirupal has actually puts it, the regulation in some places it is not clear, things are there, we are all struggling. It has been an experience in the past also, whenever any regulation comes, once we start implementing it, we actually experience the hiccups. Then subsequently, there is an amendment, there's a modification, there's a notification, all those things actually comes into place. And here also, there are a lot of things which are actually not very clear. We can actually expect. One more thing which is also not spelled out in this regulation is the regulation talks about what is the beneficial ownership, what is the thing, what is the form, what is the timing, etc., and all those things which is to be done. It says what all the things is to be done, but unfortunately, a rule is silent. If things are not done, what is the penalty? The rule is actually silent. It is not talking anything about that in the rules as such.
No, probably that they say section 90 is applicable.
Yeah,
section
that is what I also think
rules.
actually.
Yeah.
But by the think of, since it is already spelled out in the section 90, it is there.
Yeah.
Most probably that will be applicable, but unfortunately that has not been spelled out very clearly. But as you rightly say, for going with what is the already the sections are there, the same section might get applied.
Entire section will be triggered.
Yeah, that will be the case. So anyway, as we see, we can expect more amendments and modification and notification, guidance, etc., and other thing and all. And one more thing is that today, the technical features which is actually happening with the V3 format and the noting down the form, the time which is allotted by them only between April 15 to May 15, how far it is practical, how it is going to happen, any extension will take place and all, we have to wait and see. Okay, Ravina, you take over. Let us see.
Yes, sir.
Ravina, even before you started your presentation, there are already participants are very eager to know many things. They have put up a query already. Anyway, Mani, don't worry. All the things what you have put up will be get answered in the presentation. Wait for some time. Yeah.
I am so sorry for this technical glitch. Everyone, I hope now we can see the screen as well as hear my voice.
Yeah, now it is clear.
Fine.
We can see. Fine.
So sorry for delaying. I think this topic itself has given us a shiver from starting only.
200 people are waiting to hear you. Yeah.
So I'll start quickly. So basically, as sir and our panelists have said, that this has come as a Diwali gift to us from MCA on 9th of November 2023. So on 9th 11 2023, Ministry of Corporate Affairs notified that the Limited Liability Partnership Significant Beneficial Owner Rules 2023 and mandated every limited liability partnership to identify if any of the individual is a significant beneficial owner in relation to reporting LLP, and on identification, such individual has to make a declaration. So this SBO was already there in Companies Act as section 89 and 90 in Prevention of Money Laundering Act in RBI, and now it has also been come as SBO rules in 2023. In Companies Act 2013, section 89 and section 90 specifically deals with the beneficial owners and interests. So section 89, the company has to the owners has to declare the beneficial interest, and in section 90, significant beneficial owners read with companies significant beneficial owner rules 2018 is followed. In Prevention of Money Laundering Act, the company holding or entitled to hold 10% of the shares, capital, or profit of the company, or having the right to appoint a majority of the company's directors or control its management or policy decisions, is termed as significant and beneficial owner. About the definition of LLP SBO in LLP will come later on. Before that, we'll discuss some important definition so that it becomes clear when we read the SBO definition as per LLP rules. So the first term which we come to know about is control. So what which we mean by control? So control shall include right to appoint the majority of the designated partners or to control the management or policy decisions exercisable by a person or person acting individually or in concert, directly or indirectly, including by virtue of their contribution or management rights or LLP agreements or other agreements or in any other manner. Majority stake. Majority stake means holding more than one half of the equity share capital in the body corporate. Mind it, not half, but more than one half of the equity share capital in the body corporate, or holding more than one half of the contribution in a partnership entity, or holding more than one half of the voting rights in the body corporate, or having the right to receive or participate in more than one half of the distributable dividend or distributable profit or any other distribution by the body corporate, including a partnership entity, as the case may be. Significant influence is another important term which one should know while reading the definition of significant beneficial. So significant influence means the power to participate directly or indirectly in the financial and operating policy decisions of the reporting LLP, but is not control or joint control of those policies. Acting together. If any individual or individual acting through any person or trust act with a common intent or purpose of exercising any right or entitlement or exercising control or significant influence over a reporting LLP pursuant to an agreement or understanding, such individual acting through any person or trust as the case may be shall be deemed to be acting together. So here comes the definition of SBO. Rule 3, Subrule 1, Subrule K of the LLP SBO Rules 2023 defines significant beneficial owner in relation to a reporting LLP as an individual who acting alone or together or through one or more person or trust possess one or more of the following right or entitlement in such reporting LLP. Holds indirectly or together with any direct holding not less than 10% of the contribution, holds indirectly or together with any direct holding not less than 10% of voting right in respect of the management or policy decision, has right to receive or participate in not less than 10% of the total distributable profit in a financial year through indirect holding alone or together with any direct holding, has right to exercise or actually exercises significant influence or control in any manner other than through owners. So for this, let's get an explanation how this have been termed as SBO. So for this purpose of the clause, if any individual does not hold any right or entitlement indirectly is important term to know that whether the person is SBO or not. Under subclause 1, 2, 3, or 4, he shall not be considered as significant beneficial owner. For the purpose of this clause, an individual shall be considered to hold a right or entitlement directly in a reporting LLP if he satisfies any of the following criteria. One, the contribution in the reporting LLP representing such right or entitlement are held in the name of the individual himself, or the individual holds or acquire a beneficial interest in the contribution of the reporting LLP under sub-rule 2 of Rule 22B of the LLP Rule 2009 and has made a declaration in this regard to the reporting LLP. To get an clarity for such explanation, we'll provide you an illustration. So in this illustration 1, the reporting LLP has 3 partners. Partner A is holding 55% directly, B is holding 35% directly, and C is holding 10% directly. So majority of the stake of the holding is with A. So will there be any SBO? No, there will be no SBO since all the partners are holding directly. There is no indirect holding of any of the individual. Here comes the important part of the definition of LLP. In this clause, an individual shall be considered to hold a right or entitlement indirectly in the reporting LLP if he satisfies any of the following criteria. Where the partner of the reporting LLP is a body corporate, whether incorporated or registered in India or abroad, other than a LLP, and the individual holds majority stake in that partner or holds majority stake in the ultimate holding company of that partner, where the partner of the reporting LLP is a HUF through Karta and the individual is the Karta of the HUF, where the partner of the reporting LLP is a partnership entity through itself or a partner and the individual is a partner or holds majority stake in the body corporate, which is a partner of a partnership entity, or holds majority stake in the ultimate holding company of the body corporate. So for getting a clarity, again, there is one more illustration where in reporting, where one is reporting LLP and it has 3 partners. A Limited holding 30% of the shareholding of LLP, partner A, who is individual, holding 35%, and B, again, holding 35%. So indirectly, A Limited is holding 30%. Now we'll go and see who is the holder of A Limited. There are 2 shareholders, A and B, who are holding shares equally, that is 50% each. So will there be any SBO? There will be no SBO as there is no majority stake held by any of the shareholder in A Limited. In this illustration, A Limited is holding 30%, A is holding 35%, and B is holding 35%. But over here, the shareholders of A Limited are A 52%, who is having majority stake in A Limited, and B 48%. So in this case, now since A is holding majority stake in A Limited and A Limited is holding more than 10%, so directly indirect plus direct holding is more than 10% of A, then SBO of the reporting LLP is A. In this case, A Limited is holding 30%, A as an individual holding 45%, and B as an individual holding 25%. Now we will see that who is the shareholder of A Limited. A Limited again have 2 shareholders. One is which company? B Limited, and B 42%. We can see B Limited is again holding a majority stake in A Limited. So we'll see the ultimate holding of the company. So we'll see the shareholders of B Limited who are A, who is holding A as A 51%, B 30%, and C 19%. So A is holding majority stake in B Limited and B is holding majority stake in A Limited. So ultimate holding of A Limited is A. And direct with indirect, A is the SBO of the reporting LLP. In our next illustration, we see that partner A, who is an individual, who is holding 55%, partner B, who is HUF, and where B is the Karta, is holding 10%, and partner B directly holding 35%. So as we see that partner B, HUF, is holding indirectly 10% of the shareholding of LLP, B becomes the SBO of the reporting LLP. Now, if HUF is holding 9% of the HUF also, 9% of the reporting LLP also, still B would be the SBO, because indirectly plus with direct holding, B is holding more than 10% of the shareholding of the reporting LLP.
Ravina, somebody wants you to go back to the earlier illustration, because they are saying kindly repeat the illustration 4 again.
Okay. So we see that there is one reporting LLP having 3 partners. Partner A Limited, who is the holder of 30%. Partner A and partner B are individual partners, which means they have direct holding in reporting LLP, 45% and 25% respectively. Now, since partner A Limited, who is an indirect holding and it's a body corporate, will see the shareholding of the A Limited. A Limited has 2 shareholders. One is again a body corporate and the other one is individual. The body corporate B Limited is holding majority stake in the A Limited, which is 58%. So now we will see who is the shareholder of B Limited. B Limited have 3 shareholders. A, who is having 51%, B, who is having 30%, and C, who is having 19%. So in our illustration, we see A having majority stake, that is 51% in B Limited. So ultimate holding of partner A is A, who is holding 51% in B Limited. So by that means A becomes the SBO of the reporting LLP.
That means the thorough check has to be done in case of the individual. If this sort of the structure is there, the ultimately who's holding the majority of the shareholder, that is the homework you have to do.
So in case if A would have held 49% or 50% in B Limited, then there would not have been any SBO, because there would not have been any majority stakeholder.
Supriya, is it clear to you? You raise this question? There are some more questions to you, Ravina. In some of your slides, you mentioned HUF is partner in LLP. Whether HUFs can be a partner in LLP?
Yes, HUF can be a partner in LLP.
Then the next question is when to check a 10% limit.
Where if the partner HUF is holding more than 10%, we'll check that he's holding how much share he's holding as a through HUF.
Okay. Can HUF become a partner? That you answered. Here only consider 10% criteria. He's asking. We seek the holding of the shareholder. Do we just to consider equity shares or convertible instrument as well?
Over here, we'll see only the equity shares as convertible. It is still not like the voting rights. We'll see the shareholding and the voting rights.
Correct.
So,
convertible share, once it is converted, then when it becomes equity, it will be, till then it is not so. Yeah.
Exactly.
So if the direct partners in their individual capacity are having holding in LLP, then SBO rules will not apply to that LLP. If yes, then the LLP not required to file any return. Yeah, SBO rules,
yes,
does not apply, then you don't have to file any form. Your understanding is perfectly correct.
Exactly. So since direct partners are holding since individual partners are holding on their direct capacity, so there is no need to lift the wheel. The wheel is already lifted. MC already knows who is holding how much. So there is no hidden thing, anything. So LLP does not require to file any return.
Maybe their question may be little different. They are questioning the member company. If the member company has equity and potential equity, while calculating the 51% in the member company, should we consider the potential equity, that is a convertible instrument also, to identify the 51%? See, I feel we should consider, if you look at the member company cap table and dilution basis, if the cap table is made, And if you are holding 51% in the member company or even the ultimate holding company, then you will be SBO. It should be considered, because if you look at the explanation provided in the SBO rule for the 10%, the share, if you see the explanation they are provided, share includes the all convertible instrument, like maybe preference shares or maybe debentures. So they want to know the completely on the dilution basis, whether you are hold 10% in the reporting company. And if you go further, I feel even dilution basis in the member company also you should examine. That's my understanding. Maybe you can go ahead. That's the question Mr. Abhishek Agarwal was asking.
Abhishek, is that the thing you are asking actually? I also tend to agree with you, sir, what you say, Thirupal. Because when you are talking about it, I also tend to agree with that. That is the situation. Up to what layer we need to...
He says yes. Yeah, given just now, yes. Yeah. Please go ahead.
Up to what layer we need to go and find out the ultimate SBO?
Sir, the question is there in you?
Yeah, question is there actually. Up to what layer we need to go? This is, I think, Puram is asking.
It depends upon the chain that you are able to track. What law says, you at least track with the 51% criteria. Keep identifying the holding company in the reporting. Suppose there is a company which is a member or the partner in a LLP, and in the A company there is one more company, B is holding 51%, and in the B again C is holding 51. As long as that 51 is there, one should travel till to the end where individual is holding. There is no something like a number of layers like you have in the layer rule. Investment is prohibited. That rule is not applicable till you identify in the ultimate holding company who is controlling 51%. No, that particular chain should continue. One should go irrespective of the layers.
As per Section 5 of the LLP Act 2008, only an individual or body corporate may be a partner in a limited liability partnership. A HUF cannot be treated as a body corporate for these purposes of LLP Act 2008. That is what Yogesh is saying.
Yeah, see, what he is trying to tell that these HUF or the partnership firm can't be directly partner in the LLP. They should, through their karta in case of HUF, and in case of partnership firm, through their partner can be a partner in the LLP. That's all. So since that partner is not holding absolutely for his own sake, he is not a owner for those shares. So there is a requirement. In fact, 89 now is made applicable for LLPs also. Earlier it was not there. So we were capturing in the LLP agreement about the why this man is having the contribution in the LLP, and he's holding this contribution on behalf of the partnership firm or on behalf of the we can say HUF. So karta used to be identified only in the LLP agreement. Now, as per Section 89 requirement, they need to make the disclosure also directly there. Okay, it is needed now. So karta can be partner, or partner of the partnership firm can be partner.
What about the partly paid up shares?
Yeah, see, these are partly paid up shares. Then you see what is the percentage that you are getting. Suppose in a company, all are partly paid shares. So partly paid shares also are entitled to get voting rights. There is no bar in getting voting rights unless there are calls in areas and you have suspended those calls, all those things. In general, you will get the voting right. Voting right is covered is already.
I don't know, Yogesh is saying, see circular number 13 upon 2013 MCA.
No, what it says the circular?
No, he only just put this. Yogesh, can you speak actually? You are there? Can you unmute and speak, Yogesh? We can hear from you. I think our IT guy has to help. IT guy is there actually, Ravina. He can facilitate him in speaking.
Hello?
Yes, please.
Yes. See the circular number 13 by 2013. It says that HUF and the Karta cannot be a partner in LLP. So that is point mine.
No, LL. See, I'm not finding. See, a circular is mere a clarification.
Yes.
LLP Act identifies individual. Tell me whether Karta is individual or not. Tell me.
Says that it says whether the HUF and its
See,
Karta
the
can
circular,
become.
see, what we need to understand, circular cannot prohibit an individual becoming a partner, whether he holds the beneficial interest or not, it doesn't matter. See, there is another, now they have extended section 89. Think of it, why, if the circular of 2013 is valid, what is the necessary to the government to release the 89 section applicability to the LLP? Tell me, what are the circumstances? Only if you want to have 100% subsidiary as your LLP, then you will get one nominee partner in the LLP. At the same time, like LLP partnership firm wants to invest in LLP through its firm, like Companies Act also allows, Companies Act also has the same issue of body corporate and individual to recognize them as a initial subscribers. And individual can say, I am representing the partnership firm, I am representing the HUF, I am not finding any problem in it. I don't know what is the contest the circular they have issued, whether the circular holds today the 89 applicability. Then what is the 89 then? And you are prohibiting now in the SBO, now you made further complicated saying that an HUF can be, or the partnership firm can be a partner here and there, they are saying. Are they not contradicting this rule, SBO rule with their own circular?
Yes, it's contradictory actually. Yes.
No, because the point here, if I see correctly, Karta is not holding in his personal capacity as such, as Mr. Thirupal has put it. The Karta is actually holding on behalf of the HUF.
No,
that is the point.
See, the one thing we should understand, section 89 of the Companies Act. Now, of course, it is extended to the LLPs as well. If you look at the background of 89, the background of 89 is to identify the Binami transactions under the Companies Act. To identify the Binami, like suppose someone else is holding the shares, but actually is not real owner. And that to make them responsible, such persons to make them responsible to disclose who is a real owner in the form of now today the 4 and MGT 4 and 5. So that is extended here also. So there is a legal requirement that they want to invest the money into the LLPs or companies. Like the Karta wants to do the business or the HUF wants to do the business. Now you are prohibiting them to not invest in companies, not to invest in LLPs. Because they can't be members, they can't be partners over here. So which is the way via media is the one, though partner can be, or the individual can be, the HUF can be, what is that, Karta can be a partner over there, or the member in a company. I'm not finding any problem in it. Because there is a Binami transaction, they are already disclosing, clearly indicating, this is not my investment, it is my HUF investment. Similarly, the partner is telling it is not my investment, it is my partnership. So we have complied the Binami transaction name, that section also. There is a disclosure requirement. We are making disclosure. Statutorily, legally, they can't be members. So that is the reason I am becoming member. So I'm not finding any problem.
If the stake in LLB A is held by another LLB B, will SBO provision trigger for partners of LLB B?
I think Ravina, you can answer. I think you have an example for it.
Example is coming, is it? So then let us wait. If the example is coming, let us wait.
Yes, sir.
Yeah, that is the thing. So that will get answered. Also, circular number 1/13/22 dated so also. I think we discussed that.
This was addressed.
Yeah.
So,
if there are multiple layers, we will be checking only the ultimate holding person with the 51% right. Others need not be reported as SBO.
Yeah, of course, reporting will come only from the ultimate person. But the chain should be verified clearly with the 51% test.
With the majority stakeholder.
Yeah.
Correct.
Yeah, that is right.
So
we would like to know who would be the SBO in the LLP where the company A is acting as a trustee. Yeah, trustee question also being discussed. So you wait for some time. The trustee will discuss this. I think we move through the presentation, then we'll take the other questions.
Yeah, please.
Yes. Okay. So there was a question about the trust. So now the trust one
first question is getting answered. Yeah.
So where the partner of the reporting LLP is a trust through trustee and the individual is a trustee in case of discretionary trust or a charitable trust, is a beneficiary in case of a specific trust, or is an author or settler in case of revocable trust. So what are these trusts? We'll just have a overlook to it. Discretionary trust, a trust in which the number of shares of each beneficiary are not fixed by the settler in the trust deed, but at the discretion of the trustee, and where the individual shares of the beneficiaries are intermediate. Specific trust, where the individual shares of the beneficiaries are determinate, and revocable trust, assets are placed into a trust for your benefit during your lifetime and then transferred to the designated beneficiary at your death by your chosen representative. So these are the three trusts, and in this three type of trust, a trustee in case of discretionary trust, a beneficiary in case of specific trust, or author or settler in case of revocable trust becomes the SBO.
Maybe here I would like to add something about this trust, what I understood. See, all public trusts are discretionary trust. Like Section 8 companies you create. Yeah, Section 8 companies you create. Of course, company is different now. So what I'm trying to say, the trust means, if it's a public trust, means the beneficiaries at large, entire public is the beneficiary. That is the reason they say, then you identify trustee as a here SBO.
SBO.
The second one, and of course the third one, that is a specific trust and revocable trust, I believe both are private trust, like a family trust. You know, the beneficiaries are identified clearly in the trust, saying that the shares or the benefits of this particular investment, what is made to the trust will be going to the family of XYZ or so and so. So it is clearly indicated, means you can categorize into two, public trust and private trust. Public trust is meant for the general purpose, and then benefits will go to the public at large. So there the trustees are identified as SBOs, and in case of specific trust, which is a private trust, and wherein the beneficiaries are identified like ABC, like all family trust will fall into this category. And revocable, almost all it is also same way. Revocable also, suppose I have a power. See, all public trust, I believe, cannot be something like revocable trust. Trustee cannot revoke it. Trustee may not be there by that time. You know, whereas the private trust, you can revoke it. So two baskets you can create clearly. One is the public trust, other one is a private trust. So private trust beneficiaries are basically the family members of the people. And public trust, the trustee will be the person who is going to see how the fund will be distributed as per the objects to the general public. Please go ahead.
So there is one illustration stating where there is a partner which is a trust. So partner A, who is directly holding in the reporting LLP 40%, partner XYZ trust, where B is the trustee holding 35%, and partner C, who is holding 25% directly. So in this case, let's assume that XYZ trust is a discretionary trust and B is the trustee. Then B will be held as SBO of the reporting LLP. Now, where the partner of the reporting LLP is a pooled investment vehicle or entity controlled by the pool investment vehicle, based in a member state of the FATS on money laundering or the regulator of the securities market in such member state is a member of the International Organization of Security Commission, and the individual in relation to the pooled investment vehicle is a general partner or is an investment manager or is a CEO, where the investment manager of such pooled investment vehicle is a body corporate or a partnership entity. Where the partner of the reporting LLP is a pool vehicle or entity controlled by the pool investment vehicle based in the jurisdiction which does not fill the requirement referred to in clause 5 of the explanation 3, the provision of 1, 2, 3 and 4 of explanation 3 shall apply. For the purpose of this clause, individual who is acting together or through any person or trust act with a common intent or purpose of exercising any right or entitlement of or exercising control or significant influence over a reporting LLP pursuant to an agreement or understanding, formal or informal, such an individual shall be deemed as SBO. Supposedly, a company in the reporting LLP, there are direct holders who is holding the shares A, B, C. But the decision of the reporting LLP is taken by F, and the ABC is being controlled by Mr. F. Then F will be the SBO with a common who is having a significant influence or exercising control over the partners and the work of the reporting LLP.
Here the person is actually put up the question. If the beneficiary of the trustee is to be considered the SBO, do we need to consider all the beneficiaries of the trustee as SBO, or only beneficiary who is holding more than 10% of the contribution in the trust would be considered as a SBO?
So over here, sir, there is no mark about the percentage holding of the beneficiary when we see the beneficiary names. So generally, we see the partners who is having the, like, if the trust is a partner who is having more than 10%, only that criteria is seen. Then the holding of the trustee, the beneficiaries of the trust, all become the SBO of the particular trust.
Yeah, the 10% test.
Missionary or charitable trust. So since B is the trustee, B will be the SBO. In our case, B is company, then who would SBO? Then we will see the majority. In our case, B is company. Like company is the trustee, then the majority shareholding in that company.
In case of the specific trust, beneficiaries would be SBO or trustee would be the SBO.
So as Thirupal sir said that specific trust and the revocable trust are private trust. So there is they have beneficiaries. So we will consider beneficiaries as SBO, not trustees over there.
Okay, move forward. I think answer has come. Thank you.
Yes. So there is one more question which has come.
Yeah.
In case
they are saying, yeah, in case B company and it's holding 10% or more than the person holding to the company and having a majority would be SBO. Is that correct?
So in case B is a company and is holding 10% or more, in the reporting LLP, we will see the shareholders of the company B. In company B, if any of the shareholder who is holding directly more than 50%, then that person will be the SBO of the reporting LLP.
That means each time when you actually check it, the reporting LLP need to be taken into consideration. So the reporting LLP, whoever is holding, in that, what is the percentage of the sharing? With reference to the reporting LLP, is it more than 10%? That criteria is going to be checked. Yeah. I think answer has come. Correct. Understood.
So,
and one more question has come. We have two LLP, A LLP and B LLP. Now the partner of A LLP is X Limited, listed company. And B LLP and the partner of LLP is X Limited, listed company. And A LLP, is there any requirement of filing?
So there are LLPs. Now the partner of A LLP is X Limited and B LLP. And the partner of B LLP is X Limited and A LLP. So basically, we'll see the shareholding. Now, if like X Limited having more than let's say if they are holding they are taking 50%, so it is holded indirectly. We'll see the shareholders of X Limited. If there is any majority stakeholder in X Limited, he becomes the SBO of the reporting LLP. And in B LLP also, the partner of B LLP is X Limited and A LLP. Now we'll see the shareholder of X Limited again, who is holding majority stake in X Limited. If anyone is holding majority stake in X Limited, he becomes the SBO of the reporting LLP, that is A LLP.
Yeah, go ahead.
So there is one more question before that.
Not a question. Somebody is actually saying, provided the summary of the criteria, etc. Here we are actually disseminating the knowledge information with the reference thing. We cannot do somebody's specific requirement of doing the things. So that is why I'm not taking that. Provide summarizing the criteria to be considered individual HGF trust summary after the session. That means somebody is seeking a sort of a table, etc. That you can generate yourself instead of seeking us. Can I able to speak? My doubt is still unclear. Manish. Yes, you can. You can unmute and talk. There's no problem. We'd like to hear from you. Yes, Manish. IT may have to unmute.
Yes, sir.
Give you a facility to unmute. Yes, Manish. IT is there to facilitate him for unmuting.
Hello.
So I think he is allowed.
Yeah. Yes. Yes, Manish.
Hello. Sir, are you able to hear my voice?
Yeah. Very
So
much.
one more thing. As per slide 6, ma'am has said that in case the company is an SBO, in case the company is a trustee, so in that case, SBO would be company A's shareholders or the beneficiary of the SBO. Beneficiary would be the SBO. Have you understood my question? Because what the question is that the company is holding as a trustee, and trustees are there in my company, and trustee is the company.
Okay, so you are saying
Hello?
that suppose there is one reporting LLP, XYZ is the trust, and the trust who is the trustee is a company, correct?
Trustee is the company, ma'am. Yes.
Company. So suppose B is B Limited trustee. Okay. Now for this you have to normally check like who is the shareholder of B Limited.
Okay, ma'am.
So if the shareholding is more than 50% in B Limited, that becomes the SBO of the reporting LLP.
So, but in case there are laws regarding specific trust and revocable trust and all. So what's the use of that, ma'am? So in case our also a specific trust, but trustee is holding a trustee is a company. So we need to consider trust SBO would be the company's shareholders or a specific trust beneficiary would be considered as a SBO.
Beneficiary will be considered as SBO. In this case, trustees are not SBO. Beneficiaries will be held as SBO.
So, but if you have checked in the form, na ma'am, LLP form Ben 1, so they have asked only the majority of the stakeholders of the company. So that's what I'm getting confused. If you have gone through the LLP Ben 1 form format now, so they are only asking regarding the majority of the company means trust. In case of trust, na, they are only asking about the majority of the company. So that's why I'm not able to understand. We need to give the reason. We need to consider SBO. Who would be considered SBO? Company A or company B shareholders or beneficiary? All beneficiary would be considered. Only 10% beneficiaries will be considered.
So see, for beneficiary, there is no mark of 10% or 5%. 10% is for the members of the reporting LLP. In case of indirect holding. So in case if the beneficiaries are holding 2% also in the trust, he also becomes SBO because indirectly he is holding 35% in reporting LLP.
Okay. So
Yeah,
if
Mr.
you
Manish,
can
see, let me
Yes, sir.
understand what exactly you are trying to tell. Now forget about the LLP, okay? Let
Yes,
us
sir.
say
Yes.
we are into the company and you have a reporting member is another company, okay? Wherein the
Yes, sir.
reporting member is holding 10%.
Yes.
Now tell me your story. What is the next?
So in our case is that the company is a trustee on behalf of
No, why
trust.
company is a trustee? Who is a registered shareholder? Tell me.
Registered shareholder.
That's what I'm trying to say. Now let us understand. You got confused. Now I just give one example. Let us forget right now it is LLP. Let us take the example of SBO in case of company. Okay.
Okay, sir.
We'll just take your example, then we'll shift to the LLP. Okay.
Yes,
so
sir.
now there is a company A, which is a reporting entity. In that, who is holding shares?
So shareholders, meaning
Who is a
individual
shareholder? Is it individual or a trust?
Trust on behalf of trustee.
Wait. Trust is holding the shares.
Yes, trust is holding the contribution on behalf of trustee.
So wait. Trust is a registered trust, like discretionary trust or whatever it is, that is holding more than 10% in the reporting company, isn't it?
Yes.
In that company, another company is a trust. Now, who is a beneficiary over there for that trust?
So there may be many beneficial owners and individual. It would be individual.
No, is it a individual? That I told you clearly. All private trusts are basically they are discretionary, not discretionary trust. Okay, they are specific purpose trust. So beneficiaries would be the family members of a particular individual who has created the trust.
Yes, sir. Yes, I understand.
So then you ignore the trust. The trust, whether it is an individual, trust is a company, doesn't matter because it is a discretionary trust, not discretionary trust. It is a beneficiary trust, specific trust it is, unrevocable trust. So you will fall into the category number 2 and 3 of the trust.
Okay. So I need to consider all the beneficiaries as SBO.
Of course, there is no 10% criteria that you need to look at. The same is the case. It is LLP, where is a contribution is given by the another trust, and the trustee is one more company, and the beneficiaries are individual. Question is the same. Answer is the same. Okay.
Okay,
go
sir.
ahead.
Thank you so much. Thank you.
Hello.
Yes, please.
Am I audible?
Yeah, very much.
So I have a question.
Yes.
There is a reporting LLP, okay? And that LLP has 2 DP. One of the DP is company, holding 60%. And that company has 2 shareholders. One of the shareholder is also a company, holding 90%. And that company has 2 shareholders, individual shareholders. and both the shareholders are holding 50-50%. And both are husband-wife. Okay.
Okay.
So who will be
Are
giving?
they, you mean to say the wife and husband, they are not acting together?
I'm asking you whether they will be considered as indirect means.
That's what, see, in SBO, we need to understand there are 3 channels that are there in the SBO. One channel is the catching through the 51% shareholding from the member company. You keep going till you are in with the 51% majority by an individual. Okay. The next one is the control. Control of the reporting company. Who is able to control the reporting company? Now you have seen the control definition to class 27. And you know, now you will understand if anyone is having majority to appoint directors, majority to appoint this, all powers are control. Control definition itself is an inclusive one. That is the second line. The third one is the significant influence through an agreement, written, unwritten, formal, informal, over the reporting entity. Now tell me, this wife and husband, though in your given example, they may not fall into the first line. The first line I told you 51%. But are they not controlling the company? You forget about example, you lift off the corporate wheels in between. Are they not control this company? Are they not influence this company?
Yes.
They are SBOs. They are SBOs. You cannot simply test. You have to see this SBO rule purpose also you have to see. One is there is an example of 51%, 51%. It is something like to make your life is easy, but it's not that easy, the SBO rule. You have to see what is that about other words, no? Persons acting concerned together with this. Read the section 90 subsection 1. You will be able to understand. So in your case, the ultimately wife and husband, they are the only, tomorrow if this company declares the dividend and that dividend goes to the first company 60%, from there it will go to the 90% to the other company. From there, entirety will go to the wife and husband only.
Yes.
So you have to. In fact, I think Sudhakar sir would have been there. Even if you look at the Reliance Industries, I think that Mukesh Ambani sir is not holding the 51% directly in the Reliance Industries.
Correct.
Do you think they have not disclosed the SBOs?
Yes.
Simply ignore that significant influence or the control. See, our mind should be working with the concept of, purpose of why this rule was there. Purposive interpretation one should get into. If the persons acting in concern deemed to be, I think somewhere, if you see the definition, they are deemed to be acting in concern. I feel this case.
Hello.
Yes,
I
yes.
think your voice is disturbed. We are not able to hear you, Thirupal. Mr. Thirupal seems to be some voice problem.
Yes, there is some net issues from there.
Yeah, some net issues there.
Okay.
I'll try to log out and log in one more time.
Okay.
So I have more 2 questions to ask.
Yes, please ask.
Hey, 1 minute, please wait.
Okay, sir has just logged out.
Yeah, just a minute.
Yeah, please. Now, go ahead. Now I change my.
I have 2 more questions.
Yeah.
So suppose I have given a husband-wife example 50-50%. Suppose both are they are not husband-wife, totally unrelated to each other.
That is different answer. Facts based, no? Now you give another. I will give another wife and husband, but they are divorces now.
Yes, they are neighbors.
Yeah, see what we need to understand. Law is one aspect, facts is another aspect. Law we can explain you. Facts I cannot explain you unless you have the paper and before or whatever it is. So in the current situation, you have to see the facts. Law we understood. If you go only 51%, that criteria, no one will be the SBO. But ultimately, they are the person getting the entire money. And they are wife and husband, and they are person acting. There is a acting concern also there, no?
Yes.
Okay. Please, I think you are done with the questions.
Yeah.
Yeah.
Yes,
Go ahead
Ravina.
now.
Thank you, sir.
Thank you.
Who will give a declaration in that case? 50%.
Sir, Jayashree, have you done your query?
Yes, actually, we would like to only ask the simple last one that if the both are husband and wife and they are having 50-50, then anyone can give a declaration or both has to give regarding this?
Both should give declaration.
Both should give. Both should give.
Okay.
Because we are not getting into the 51% criteria, no? So individual, ultimately we are able to identify the individual. It's fine.
Okay. Thank you.
You can mute yourself.
I'm done. Yes.
Yeah, go ahead, Ravina, now.
Yes, sir. So now we'll see what is the duty of the reporting LLP. The first and foremost duty of the reporting LLP is to identify if there is any individual who is an SBO or not in relation to that reporting LLP, and if so, identify him and cause such individual to make a declaration in form number LLP Ben 1. Now, since Jayashree has asked us a question that if there is a husband and wife, should they give a declaration suo moto, or like should they give or not? It's a duty of the LLP to ask them if the LLP thinks that the individual is an SBO. It shall give a notice in LLP Ben 4 to the individual and ask them to make a declaration in form number LLP Ben 1. Every reporting LLP shall, in all cases where its partner other than individual holds not less than 10% of its contribution or voting right or right to receive or participate in the distributable profit or any distribution payable in a financial year, give notice to such partner in form number LLP Ben 4, seeking information in accordance with subsection 5 of section 90 of the Companies Act 2013 as applied to the limited liability partnership as per the notification. So, declaration of SBO. Declaration to be made in form LLP Ben 1 to reporting LLP within 90 days from commencement on these rules. An individual who subsequently become SBO or his SBO undergoes any change, then declaration has to be made within 30 days of acquiring such SBO or any change. Changes in SBO during the transition period. In case an individual becomes an SBO or where his significant beneficial ownership undergoes any change, within 90 days of the commencement of these rules, SBO or any change has therein happened on the date of expiry of this rules should tell to the reporting LLP accordingly. So we see the obligation for initial disclosure is within 90 days. It is every time said from the rules rules where it has been made applicable. So the rule was made applicable on November 9, 2023. So from there, henceforth, the days 90 days will be counted, which becomes February 7, 2024. Although we see that form Ben 2 has not yet come due to the change in the version from V2 to V3, still Ben 1 has to be taken before February 7, 2024. So,
Ravina, 1 minute. There are two more questions which actually has come here.
Okay.
Further, either a concept of ultimate holding LLP, let us say in company structure involving LLP only, and what is LLP is a partner in LLP. I think Mr.
What if?
Thirupal could answer. In fact, I think if I'm not mistaken, correct me, Thirupal sir, a LLB cannot become a partner in another LLB if I'm understanding correctly.
It can be, there is no problem because LLP is a body corporate, it can be partner, and we have created, I think 3 or 4 structures like that. One LLP is holding partnership in other LLP, and system allows us. There is no problem.
So here
LLP can be a partner.
Here the question is there a concept of ultimate holding LLP in a complex structure?
Yeah, I see the Companies Act, they have extended concept of holding company definition also there. If you look at the holding company definition, it includes the body corporate. It includes the body corporate. Similarly, if you see the definition of subsidiary, that section 2 clause 87, there also it is written body corporate. Body corporate, it includes body corporate. Company, the expression company includes body corporate. And if you go to abroad, you will find many LLPs also coming to India and investing in the Indian companies, in the form of company, in the form of LLPs they are doing. So in India, only the problem with our definition of subsidiary. Definition of subsidiary says the language should have been aligned. Even many times we have modified the subsidiary or any other definition, but the language is not modified to capture the other structures. It says only the body corporate directors, majority of director holding 51% voting power and all. These 2 should be extended, saying that if there is a body corporate governing council, and if there is a LLP, then they should say it is like a partner, LLP designated partners. And similarly, if there is a what is that called majority of partner, instead of majority of partner, it should go with a designated partner. And then contribution. These things are not properly captured in the subsidiary agreement, subsidiary definition, and which is a means. The definition is not an inclusive definition. So there is a saying that though you hold 100% in your subsidiary LLP, but you may not term as per LLP Companies Act as a subsidiary. Subsidiary company. You cannot term as a subsidiary company. But if you look at the Ind AS or accounting standards, they have identified even LLP for the consolidation purpose. So there is a flaw in the definition of subsidiary. So in the Companies Act, whatever the definitions are there, they are even equally applicable to the LLP, because if you look at the LLP Act, the last definition before that, there is an expression. Words used in this act but not defined, one should refer to the Companies Act as well. Not only in the LLP rules of the beneficiary, even if you go to the LLP Act also, they have said clearly we are supposed to refer certain terms from the Companies Act. So right now, if you go by the, what is that called, by letter, yes, there is no concept of ultimate holding company or ultimate holding LLP and all. But if you go by the spirit, the purpose, yes, there is a possibility of you having ultimate holding company. Courts may not alone go with only the letter. Courts will go with the concept called spirit also. So if you get into the spirit concept, there is a possibility the ultimate holding LLP also will be, which is allowed also. Sir, you are in mute. Still in mute.
Yeah.
Yes, sir.
Change is also required to be intimated if SBO reduce shareholding from 70% to 65%, whether it is required to be filed in MCA, what is the meaning of change?
Yeah, that's what. In fact, my opening remarks was this only. I think this I think Anil Shah, I think, would not have been there. Change inclusive of, I think it is. It could be change. But technically, if someone is already, see, tell me what is the purpose of SBO? Why they brought the rule of SBO? The rule of SBO is there to identify the person behind the curtain who is running this, doll.
पर्दे के पीछे कौन है?
हाँ, पर्दे के पीछे कौन है? who is running this doll and with the threats called another companies, other LLPs or other trusts. Who is? Kone. That is exactly. Suppose we have already brought in, someone is already holding 10% and we made his name announced to the public or to the government, and whether he's holding 10% or 15% or 100%, it has no sense now to say, yes, we say he is SBO and his name is clear. So one way sense, if cease to be, if you go literal sense, if you go, change could be anything. But if you go with the purpose, change should be like when you become a SBO or one, he cease to be SBO. You have to go either ways. But here there is no say. Simply they want to capture everything. So even if you increase your shareholding, decrease your shareholding, see, as I told clearly, the given example of I think other lady had given example, like you have a reporting LLP, over there 60% contribution held by the other company, and over there is a 90% shareholder by another company. Over there is a 50-50 shareholding between two individuals who are wife and husband. Now I will try to understand, make you to understand the word change. Now, husband transfer one share to the wife. Tell me, is it not a change? Now, instead of 90% stake, they have enhanced to the 95% in the ultimate company. Tell me, is it not a change? And instead of 60% in the second layer company, they have reduced to 51%. Tell me, is not percentage. Change could be anything. Similarly, in this particular reporting company or LLP, there is a rights issue and they didn't subscribe. Due to that, their shareholding has come down from the 60% to the 40%. Tell me, is it not a change? Is it due to me, due to SBO, the change happened? There is a share transfer and or not share transfer, buyback has happened, and I didn't participate in the buyback. So earlier I was holding 35%, and because I didn't participate in the buyback, my percentage went into 45%. Tell me, is it not a change in the reporting company? So change could be anything. Change could be anything. So they want to cover broadly the change word in any level, in the chain of the companies, or the whatever the control that you have, or whatever the significant influence, anything could be a change. At least they should make clearly cessation of SBO. One separate radio button should be made. Rest can be put into the basket of change. They can add whatever you add, addition, removal, everything could be the change. So this is my understanding of the change. Change could be anything.
If all the partners in LLP is individual, whether SBO rules applicable, if not applicable, any form, this we answered actually.
This was addressed.
Yeah, this is the same question which is repeated. Can a partnership formed under the Partnership Act 1932 become a partner of LLP?
This is the SBO rules assumes that it says that partnership from other partner, something like that. So we assume that SBO rule cannot give an amendment to the LLP Act saying LLP Act clearly says body corporate and individual only can be partner. This SBO rule cannot make. The whole idea of SBO rule is the shareholding is through individual, but it is meant for the LLP. That situation they are trying to help. Similarly, shareholding is there in the form of trust, but the shareholding, the trustee is holding for the purpose of the trust. That is a objectivity of making them as a member. Otherwise, they cannot be member as per the law. Only few exceptions may be there. Example, employee trust may sometimes be recognized there. Here also, I suggest to incorporate only names of the trustees, not the trustee. The new act, people say that trust recognition should be, the provision was removed, so now you can recognize, but that is no question whether you can recognize or.
Yes, Ravina, go ahead.
So as the questions were answered by sir, we'll now move to our continual disclosure, which is being asked as one of the question also, like when it has to be filed, when the SBO or any individual who subsequently becomes an SBO, or whether significant beneficial ownership undergoes any change, will be required to file a declaration form number LLP Ben 1. Now, to extend this changes, like which change has to be reported. So basically, if any individual who subsequently become an SBO, suppose first in first year the SBO was A, but in the later in the during the year, the shareholding from 10% it becomes 9% due to transfer, and somebody else becomes the 10%. So these change has to be reported within 30 days. So the 90 days time has only been given in the initial time, that is till February 15th 2024. After that, it has to be reported within 30 days, as and when the change comes. So next is return of SBO. The reporting LLP will have to file a return in form number LLP Bend 2 with the registrar within 30 days from the receipt of such declaration. In view of the transition of MC21 from version V2 to V3 and to promote compliance on part of reporting LLP, MC dated 7th February 24 informed that reporting LLP may file form LLP Bend 2 and form number 4D without payment of additional fees up to 15th May 2024. The two forms shall be made available in version 3 for filing purpose with effect from 15th April 24. So till date, the form has yet not, which doesn't mean that Ben 1 should not be taken by the reporting LLP. The reporting LLP should have Ben 1 before 7th of February 2024, and the filing of Ben 2 will start from 15th April, and the time limit which has been given till now by the MCA is 15th May 2024. Now we see that the reporting LLP has to maintain register for SBOs. The register of SBO to be maintained by LLP in form number LLP Ben 3. The register shall be open for inspection during business hours for not less than 2 hours and with a fees of rupees not more than 50, not exceeding rupees 50. So, can the LLP apply to the tribunal? Yes, the reporting LLP shall apply to the tribunal where any person fails to give the information required by the notice in form number LLP 10.4, or where the information given is not satisfactory under section 90, subsection 7 of the Companies Act 2013. Here we see that there are a lot of places where LLP has taken help from or guidance from the Companies Act. Like there are various sections which are applicable to the LLP rules also. Like we see in section 90, subsection 7 of the Companies Act 2013. Similarly, in penalty known of any particular rule or section in LLP SBO rules or the LLP Act of non-filing of the form. But here also, like order of adjudication of penalty under section 454 of Companies Act 2013, read with Rule 3 of Companies Adjudication of Penalties for violation of provision of Section 90 of the Companies Act 2013 would prevail. But as Balasar told, that penalty section has not been declared till date. So, for whom this LLP, this SBO identification is not mandatory or not applicable. So, LLP held by central government, state government, or local authority, reporting LLP, body corporate, or entity controlled by central or state government, an investment vehicle registered and regulated by the Securities and Exchange Board of India, or an investment vehicle regulated by the Reserve Bank of India, or Insurance Regulatory and Development Authority of India, or Pension Fund Regulatory and Development Authority, does not have to mention anything about the SBO, even if they have holding indirectly more than 10% by any of the government companies. So, to conclude, we say that the SBO LLP SBO rules 2023 mandates LLPs to adhere to SBO declarations, file SBO return, and maintain register. The object is to ensure transparency and accountability by identifying and disclosing the individual who ultimately hold the beneficial interest and marshal the strategic decision making within LLPs. As we said, पर्दे के पीछे कौन है is the ultimate factor of this SBO rules. The purpose of these rules is to bring fair and disclosure of holding and cross holdings into a practice and lift the veil to identify the individuals actually owning or running the entity. Thank you.
Excellent, Ravina. You have summarized everything together at a span of time, nicely explained. There are 2 or 3 more questions which is actually asked here.
Yes, sir.
Time limit for newly incorporated LLB, suppose LLB has 17 to 24 to submit declaration about SBO. You already said actually the SBO rule which has been notified, which comes into effect from this date, you know, to follow that. Can you please repeat criteria for the then 1 to 3 again, please? I'm not able to follow what is this. Alpesh Power is saying, what is this?
Can you please repeat criteria for Ben 1, 2, and 3 again?
Yeah. What is there?
So,
Ben 1 and 2, 3?
Ben 1 is given by the SBO. Ben 2 is the form which is submitted to the MCA by the reporting LLP, and Ben 3 is the register of the SBO. Like who is the SBO LLP has to maintain a register, and Ben 4 is the form which is the notice which is given by the reporting LLP to the shareholders who is holding more than 10% or who is holding indirectly who is holding the more than 10% in the reporting LLP.
Yeah, as you rightly say, 1 to 3 is the requirement of the law. But he has used the word in between. What is the criteria? Criteria she has already explained. Ultimately, to be a transparency identified, she used the word "पर्दे के पीछे कौन है." That is the whole criteria on this.
So criteria for this is the who is holding not less than 10% of its contribution or voting right or right to receive or participate in the distributable profit, they will get Ben 4. And who is holding the ultimate, the individual who is holding the significant interest in the LLP has to give Ben 1. And this report has to be given in Ben 2. If suppose there is no SBO, then Ben 2 need not to be filed. And then similarly, Ben 3 has to be maintained.
What would be the due date for LLB in case of the partner is a company and significant owner makes delayed disclosure of the change on his shareholding?
For LLP, in case partner is company and significant owner makes delayed disclosure of change in its shareholding. See, due date is given whenever there is a change within 30 days. After that, late fees will be charged. Till now, the form has not come. But if the delays, even if it is delayed by the shareholder also, the delay, ultimately the delay is happening for the LLP, he cannot file, it cannot file Ben 2 form unless it gets the...
unless Ben 1 comes, Ben 2 cannot be filed. Ben 1, if he has not given, then as you say that identification, checking, etc., then taking up with the NCLT, those processes will be applicable. Exactly. And Ben 2, in any case, it can be done only after the Ben 1 is received. Some appreciation has come to you, nicely explained. If the all partners of LLB individual and directly contribution is equal ratio, whether SBO rules applicable. She has already said, no, if the partners are directly holding, the question of beneficial ownership does not arise at all.
Exactly.
That she has already made it very clear. Whatever may be the proportion, etc., that is immaterial. The direct holding is there by the partner, then there is no question of beneficial owner concept itself is not there actually. Then again, what is that? No, yeah, one more thing has come. Can you please explain Ben 4 form?
Okay, so Ben 4 form is given by the reporting LLP to the partners other than individual who is holding not less than 10% of its contribution, that is who is holding indirectly in the reporting LLP. So Ben 4 form LLP, Ben 4 is given by the reporting LLP to the indirect holders of the reporting LLP. It is a notice which is given to such partner who is holding not less than 10% of its contribution or voting right or right to receive or participate in the distributable profit. It is clearly mentioned in the slide. And the similar thing is also there in the Companies Act 2013 also, where we have already worked on that. The LLP, like Ben 4, is given in the companies as well, who is holding indirectly in the company.
Again, the same question is coming. If the LLB, all the partners individual only, whether Ben is required to be filed. No, question of the substantial beneficial owner does not arise at all. If a partner has 60% share directly and also indirect holding 10%, whether he is required to file Ben.
He should see what is
So
indirect.
yes, indirect.
What is indirect, he should explain to us.
Yeah.
If it is a company, then if it is
Correct.
a partnership form, if it is a so trust route, then you have to comply SBO, no option.
He is holding indirectly more than 10%. Even if he is holding 9% and then indirectly, then the directly plus indirectly will be combined.
I think that's all the questions are there. I think I will ask Mr. Thirupal to say his last words on this.
Yeah, see, what we need to understand, see, someone was telling, I think people must have aware of the 2 notices that were given by the MCA for non-compliance of SBO rule by the companies. If you look at those 2 notifications or notices, so-called notices issued ROC or MCA, that is server system, it says it identifies the whether Ben 1 was delayed or Ben 2 was delayed. Because while filing the Ben 2, you will be clearly mentioning what is the date of receipt of the Ben 1. Suppose if there is a delay in filing the Ben 1 and company is not penalized, but company should ensure that from date of receipt you are filing that within 30 days. You got my point? So if there is a delay in Ben 1, and company should have a proof when it was received, from that day you file within 30 days. And company is not held responsible. So if the payment is received in time and you didn't file in time, means as a company you have 30 days time, then you are responsible. So if you see the old so-called notices, you will clearly have 2 baskets, whether there was a delay in Ben 1 or delay in Ben 2. 2 baskets. You can separate them clearly in 2 baskets. Now you have to analyze. The analyzation is that what is the impact of it? See, I have been asked by some companies, if I delay in Ben 1 or if I delay in Ben 2, what is the consequences for that? There are clearly legal provisions are there. Delay in filing the Ben 1, only the particular individual will be held responsible with certain penalties are there. I think section 6 or 7 is there in the 19. So delay in filing the Ben 2, delay in maintaining the record, and delay in taking the action like not giving the Ben 4, seeking the information about the SBO. There is a separate penal provision for the company and its officers. So just keep in mind, based on that, you should be having a protection to the company. Suppose there is a delay in Ben 1. If it is a case where not a promoter and all, you should certainly have evidence that when you have received it, so that the company will be protected from the penal provisions. Have the proof that if he sends through the mail, then have a mail, communication, even including the body of the mail also can be added and enclosed to the Ben 2 while filing the Ben.
You are absolutely right. You are absolutely right, Thirupal sir. In fact, I have seen cases decided by Bangalore ROC.
Yeah.
In fact, very clearly where the Ben 1 was delayed, company was not actually penalized. That only the people who failed to give intimation, they were penalized.
Correct.
Of course, there were cases, even after giving the intimation, they are not filed in time, they are penalized. And again,
Yeah, there is another basket also, sir.
Yeah.
Where both delay in file receipt of the Ben 1 and filing in receipt. Also, both are, delays are there. And there is another basket, both company and the individual, both will be held responsible.
Not only that, while waiving the penalty, there is a fixed penalty and also continuing delay the number of days. That is also there.
Yeah.
In case of the shareholding of the SBO reporting company get changes due to additional allotment of the shares by the reporting company, then SBO should give intimation to the reporting. I think you have an elaborate discussion on this.
This I have already explained
yes, already
clearly,
explained.
additional shares. I think these 3-4 hands were raised. You just check with, still they have anything to ask?
Now MCA has extended filing the Ben 2, is it right?
Yeah, it is there. There is
Yeah, it is there. Yeah.
So
I think there
have
are
given
hand,
them.
It is Ben 2 only, LLP Ben 2, not for the Companies Act Ben 2. That we should keep in mind.
Sir, I have one.
I think
May I ask it?
KV Kabra is also
Mr.
question.
Kabra.
Yeah, thank you, sir. Thank you for taking my question. So my question is, suppose in X LLP is a partner with 60% holding.
Yeah.
So he is already majority holding.
Correct.
Now, a company is also partner in this LLP, whose shareholding is 30%. And this person is shareholder 50%.
Yeah.
So direct 60%, he is already majority holder. Now again through X Limited, 50% means 15% of 30%. So whether it's required to file Ben 1 because it's already disclosed that he is a majority shareholder.
See, the criteria, what we need to do, what we need to understand is SBO, wherever shareholding is held through company, held through body corporate, or held through the trust, held through the partnership forms, held through the LLPs, if it is more than 10%, government would like to know this mask, the mask of, they want to remove the mask of the 10%. Find out who is behind the mask. That's all. That is objectivity. The same person may hold 51% directly as shareholder. It is immaterial to them. He may be holding directly in one hand, 60%, his name is already there. Doesn't mean that the 10% he is holding through the company need not be disclosed. It's not so that law is not applicable to 60%. Law is applicable to only 10%. We are worried about the 10%, which is masked through the companies.
Right, sir. Quite clear. Thanks a lot for that. Thank you.
Magesh, can you talk? You raise a hand.
Mahesh Singh.
Magesh Singhi.
I don't know.
He is not there?
Yeah.
Then we can ask
Hello.
Alifya.
Yeah, he's there.
Yeah, yes, Magesh.
Yeah, sir, good morning, sir. If there are two companies, body corporate, who are the designated partner in LLP,
Yeah.
and in that two companies, again, there are individuals who holds 8% each, 8.31% each. So in that case, how SBO would be applicable, and will all the individuals who are the shareholder in those companies comes under or fall under the SBO in LLP?
Yeah. Unless you have that is a person acting in concert, and this 8.33%, whatever it is, in general, SBO rule is not applicable because you are not able to find any majority shareholder, 51% holding in that particular partner company. Okay. So it is not.
But all are relatives, either father, daughter.
Yeah, that's what again I told you. In fact, it was explained one wife and husband case. It goes based on the facts. And when you were that they are going to control that company, may not be through shareholding. You should go with other criteria like control and the significant influence.
Okay. So it will fall under control. You can say directly will have to.
Yeah, you have to. That's what. Now you should open the definition of control to class 27 in case of company, and here they are defined differently. So both you get into that, then you will get a fair idea. So it is simple that entirety, maybe in channelized way, entire water is coming to the same home only. You have got open 2-3 channels to get water. So doesn't mean that you are not getting 100% water into the same.
Okay.
Yeah.
Yes. Thank you.
Next.
Thank you.
Amit Shah? Amit Shah, can you speak?
One more, Akshita Poli.
Yeah, Akshita Puri. Are you there, Akshita?
Should be unmuted, I believe.
Yes, unmuted, sir.
Yeah.
Akshita and Ami, both are there. They raised their hands.
Okay. I think next question is one Srivani.
Sir, in the chat box, there is one question.
Yeah, let us see.
If a reporting LLP has two partners, individual A and company B 10%. So we are going to see the shareholding of B Limited. Then B Limited has three partners, individual 30%, A, B 25%, XYZ LLP 45%. Now, in this case, none of the shareholder is having a majority stake in B Limited.
Yeah.
So there will be no SBO.
Yes, that's what we concluded. Unless these 3, 4 are,
related,
acting
together.
Yeah, that was deemed provision in there.
If a
Exactly.
director in a public company hold 90%, and another company also is a director, and that company hold more than 10% of the public company, would Ben to be filed?
It is like CS question. So director nowhere is spoken anywhere in the SBO rule. The director, content, director, all those things is not spoken. It says clearly whether he is holding 51% in the other company which holds 10%. That is the first criteria issue. We should test it, not the director position.
And LLB went to by LLB is required to be filed by reporting LLB within 30 days of receive the notice. If the reporting LLB receive notice of the change after 30 days of the change of, let us say LLB receives notice after 90 days of change, in that case, whether LLB would be liable to the additional fees or not.
This was explained already.
This was explained. He talked
We
very
have said,
clearly.
when one delay and when two delay, and both delays, 3 baskets you make it, then you will get accordingly penalty.
Both public and private company held by the same directors only. In this case, Ben to required.
Directorship never been a criteria in the Ben rules or in the LLP Ben rules. It is only shareholding and control and then significant influence.
That is all I think so. The questions are, one more thing has come. What is that? This question is for a company. We have a scenario where the SEBI registered trust or the holding compulsory convertible shares in the company, and on fully diluted basis is holding 10%. But when asked for Ben 1, then the entity replies saying that our SEBI registered fund, that is not applicable. We were unable to trace such notification. Kindly assist.
There is no notification. I think if you see the Ben rule that he was telling company Ben rule number 8, I think. Rule number 8, sub-rule number 8, there the exemptions are provided. If they are claiming the exemption under that category, probably Ben may not be applicable to them. So like there is a government company is there, and there is a, the reporting holding company, there's one more exemption is there. Thereafter, these kind of registrations like SEBI registered regulatory and all, some exemptions are there. Just get the rule.
I think that's all I think so. So we are done with all the things.
So we can ignore these hands which are lifted.
And Magesh, he has answered. Ashita and Ami, we talked.
This two, I think they didn't.
Yeah, on one more is there now, Sushil. Yeah. Ami is actually lowered on the hands now. So Sushil is there.
Yeah.
Yes. Can you speak?
Yeah,
Sushil?
yeah. Hello.
Yeah.
Yes. Yeah. In case of exact 10% shareholdings of 10% holdings of company, we need to determine ban or not. Not less than 10%, not more than 10%. In case of exact 10%.
Yeah, it is. It is. We have to get. It doesn't say 10% more, 10 or more.
So, in case of exact 10%, we have to determine.
We have to assess we have to investigate and assess whether there is an SBO in this.
Okay.
Ashita, are you there? Your hands are still right. Again, I can see Abhishek also. Any one of you?
Abhishek Jain.
Abhishek?
हेलो
या
एक एलएलपी के केस में अगर कोई रिपोर्टिंग एलएलपी में 10% डायरेक्टली होल्ड कर रहा है बट इनडायरेक्टली उसने फंड किया है किसी अदर शेयर होल्डर को भी लाइक उसकी वाइफ या किसी और को भी पैसा उसका लगा हुआ है तो उसको भी रिपोर्ट करना पड़ेगा
सुनिए इधर वो indirect reporting through entities only recognized right now.
Okay.
Indirect reporting holding through entities like companies, LLPs, trust, partnership firms. Okay, or any body corporate. Okay. So if your case, the money was put through the other individuals, probably the section 89 is applicable because he is the beneficiary. They are the only registered owners in case of companies. In case of LLP, they are just mere, what is that called, dummy partner kind, and the benefits will go to him. So probably the section 89 should be complied. And if you have complied 89, I feel 89, if you have complied, then Ben is not applicable. It is written in the clarification.
अगर यही केस ट्रस्ट के केस में हो मतलब कि उसने इनडायरेक्ट फंड किया हो तो
वो आ जाएगा ना ट्रस्ट बोले तो ट्रस्ट इज अ मेंबर हियर होल्डिंग मोर देन 10%. Now all beneficiaries of the trust that must be family trust means this trust may be specific purpose trust. So the all individuals behind the trust being beneficiaries will be the SBOs here.
Okay. Thank you.
You need to understand ramification of disclosing 89. It may be clubbing of income under income tax also. There is a provision in income tax. SBO disclosure is there even while filing the income tax return also. There is SBO disclosure is there. And also what is that? 89 disclosure also there. So one should be very careful. If you are doing disclosure to the ROC means, they may need to stick to the same disclosure with other departments as well.
Okay. Even non-resident ultimate has to file these forms.
Yeah,
it is. Suppose there are nothing reporting LLP in which one partner is LLP holds 49%, another is actually 51%. Again, the LLP holds 49%, 75% held by another LLP and other by LLP. Would you please suggest who will be the SBO? You have to do the testing, na?
You have to see the testing of 51%. One is the 51%, let him test. Second one, let him test the control. Third one, let him test the significant influence.
Correct. In case of an LLP whose partner are two private limited companies having 50% contribution each, the partner of both the companies do not hold 10% or more share in the company, will there be an SBO?
No, you see, the two companies having 50-50, technically we should test who is controlling those two companies. With 51% test or with the control and all, then it will be there. Otherwise, there is no SBO in this case.
I think that is all. We can close the session with things. There are a couple of appreciation has come to you. Ravina, once again, thanks. Excellently, you put it very nicely and brought out those things, etc. Thirupal, extremely, I must sincerely thank you for your excellent practical experience sharing. It is really, lot of learning today actually for me. Since I am being an old timer, I am keeping in touch with it. These are all the things which is coming near you. With your practical experience really helps me in knowing the things, much more things actually inside of it. Very great. Thanks a lot for your sharing the knowledge.
Thank you for providing opportunity for learning. Okay, thank you.
Thank you very much,
thank
sir.
you to
We
the
look forward to you for a future session also. Sometime you are always there, as Sudhakar puts it initially. Thanks a lot.
Thanks
I
to
think
all,
with
thanks
this
to all
we
panelists.
Yeah.
And
Thank you
then
so much,
presenter.
sir,
Thank you.
for
Thank you,
clearing our doubts and intricacies of the LLP rules, which has come newly, and have solved lot of questions and have given clarity in holding, not holding directly, indirectly. So I guess all participants, including us, we have got to learn so many things, and will apply on the like when we will do it practically.
Yeah. Thank you. Thank you to all.
Thanks a lot. Thank you to everybody. Have a good weekend. We
Yeah.
meet yet another session in the next one. Thank you.
Thank you. Thank you to all. Bye.
Thank you.
Good day to all.